Yes.
I'm enjoying it. Only pass by the last certificate. What is happening, Your Lordship? This is expiring on 31st. And 31st
We'll
is
have
falling
it-
on Sunday.
This Sunday? Tomorrow? Tomorrow. To be mentioned. To be mentioned, we'll keep it in.
Mention.
Have you served the other side?
I'm informed the other side.
Must serve them.
Well, sir.
This the matter is steamer.
Yes.
Steamer.
Yes.
Vote number
All right.
Let it come on Tuesday.
Tuesday. Yes, let it be on Tuesday.
Okay.
Tuesday.
Another matter.
Electricity matter?
There is a direction to file evidence in operation within fortnight. This matter was lastly appeared before the solicitor to 7th January. Thereafter, this matter has not been.
Who's on the other side?
Administration.
Have you informed the other side before mentioning? No mentioning without informing the other side. Mention it tomorrow. Yes, madam. वापस करो. हाँ. Item number 2.
Yes.
I wait for.
already served the copy to the respondent.
What's the hurry of mentioning item number 2, madam? Who's on the other side? That's all right. I'm saying, what is the hurry of mentioning this matter will come? Why are you mentioning it? Wait for 2 minutes. Wait. Madam, wait for your turn. Wait for your turn.
Item number 44.
Yes, sir. Item 44. Who's on the other side?
So this is a revision that has been prepared against discharge of accused persons. We are appearing for the accused persons. There are 2 revisions. One is by my learned complainant, the other is by the state. I have no objection in my.
Who's for the state?
Mr. Karmakar, the public person.
Let him come. Call the other side also. Mentioning without other side, I'm not going to allow.
Let it be till the next Saturday. Senior is having some problem.
No, that's okay. But where's the other side?
His Lordship, on behalf of Mr. Karmakar, I am okay.
All right. All right, then I think all the parties are here. Which item number? 40?
49 and 50.
49 and 50. All right.
But I pray your lordship kindly mention.
Just
Praying leave to file a revision, criminal revision without the certified copy.
without certified copy, it will be done.
May I say this? Under the rules, the certified copy is.
We'll see that. Let me just give an order in this. In item 49, at the request of the learned counsel of the petitioner, the present writ petition is, let this matter be listed. Learned counsel of the petitioner prays for this matter to be listed before the next available circuit bench, full stop. At his prayer, let this matter be listed before the next available circuit bench. Item 49. Item 50. Let this matter be listed along with the connected CRR 54/2024. Full stop. In the next available circuit bench. Both the matters to be listed together. All right. Now,
Under chapter 5, rule 9 of the appellate side rules, we are supposed to present the copy of the revision provided together with the service of the order we are challenging. Now, the difficulty here is an order on 156.3, it's a new 175.3, right? Registration. We have applied for the certified copy of the order as well as of the copy of the 156.3 petition. The FIR has not yet come, although it's been registered and will only come here in November. However, even though this is the rule, there are 2 judgments of the Honorable Court dating back to the 80s for the original side and the appellate side, that we can move the application with the Xerox copy, provided we are showing that we have applied and it's not available, and we give an undertaking that within the period of limitation, we will supply the certified copy to the registry. And but if your lordship so desires, I can bring those two judgments on that basis if your lordship grants relief. And the third thing is that recently in the Supreme Court, a bench headed by Manifestus Bhakto, that is Harsh Bhuvalka, in a matter arising out of Calcutta High Court, his lordship has dealt with the matter in the Supreme Court, where your lordship is aware those exemption applications are filed. Where his lordship has said the same thing in practice, you will have to demonstrate that you've applied for it and you've not yet got it, and you will give an undertaking that you will do. And on that basis, because there is some urgency involved in the matter. If we have to wait for the certified copy, we'll get only the order. The FIR we won't get now in any event. We are supposed to upload the FIRs on the server within 24 hours or so. Even that is not good. So that is why I'm not bring the light of the urgency. I'm praying for that. If your lordship so desires, tomorrow I'll come back and we'll show you those orders.
Yes, just show me those orders, then we'll.
I'll come back. And item number 1 is fixed today as my instance.
Yes,
This is the matter with regard to electricity cases.
yes,
And there have been contrary orders
Yes.
which have come in conflict with. My learned friend has filed this affidavit in opposition. I have filed my rejoinder to that, serving a copy here. Matter is ready for hearing.
Let it come on Tuesday.
give me the rejoinder, copy of the rejoinder. It's already on record.
Your lordship, I could just briefly just describe the situation. My lord
Yes.
takes up the supplementary affidavit.
Let it come on Tuesday.
Let me just understand. I'm not passing any order. Just let me understand what.
Part by part by Tuesday, only he can.
Only he can argue first. Let me understand whether I'll be able to finish it or not. Yes. Supplementary affidavit, you're saying?
The lordship kindly takes up the supplementary.
Yes.
Now, first and foremost, this issue with regard to the electricity connections is something which has been changing through the years. My lord will see page 36 first of the supplementary affidavit. This is annexure S3.
Yes.
This is a judgment of this honorable court passed in 2011.
Yes.
Because there were a series of decisions, whether or not in terms of the Electricity Act 2003, a person who encroached on government land could come and apply for an electricity connection. This matter ended up being referred to the Constitution Bench, and the Constitution Bench has answered those questions by framing 2 points. The first point is whether or not electricity, Master will get this at page 37, paragraph 2. The first is whether an unauthorized occupier or encroacher can say that he is an occupier and ask for electricity connection. The second is whether the right to have an electricity connection can be deemed to be part of the right to life under Article 21. Of these two questions, my lords did not answer point number 2 because they answered point number 1 by saying that there is a well settled position in law that we are not settling the rights and title over the property. All we are doing is saying that if he is in settled possession of the land, he may apply, and their lordships interpreted the law accordingly. Now, thereafter, your lordship will find at page 48. Following Abhimanyu Mazumdar, there have been a series of orders which have continued from 2011 onwards. One such order is annexed at page 49, where mandamus was issued on the basis of Abhimanyu Mazumdar by saying that he is entitled to apply.
Yes.
Now, the difficulty was in 2011, Abhimanyu Mazumdar dealt with the Electricity Act 2003, but there was an amendment in the Electricity Act. That amendment, unfortunately, while the judgment was being typed, was copied from the old statute, which did not have that provision.
Which judgment which was being typed?
Abhimanyu Mazumdar. So Abhimanyu Mazumdar, if my lord sees, they have referred to the relevant provisions of the Electricity Act at page 41, your lordship will get it, section 43.
Yes. Yes.
Now, this has undergone an amendment, it is true, and we are aware of the amendment as well. Your lordship will see the amended version at page 26.
Yes.
I have taken the extract. On the next page, my lord will see explanation. The second paragraph at page 27. For the purposes of this subsection, application means the application complete in all respects in the appropriate form as required by the distribution licensee, along with documents showing payment of necessary charges. This was inserted in 2007. So in 2011, when the bench was hearing the case, they considered it. But in the judgment, which is referring to 43 at page 41, that explanation is missing. Because the setting out has been done from an old book. So this is one thing. The second thing is in 2018, the JERC has come out with the regulations as per which now new connections are to be given. So this is very voluminous, but the relevant portion is at page 50. Page 50, clause 5.30. Any of the following documents shall be considered as acceptable proof of ownership or occupancy of premises. 1, 2, 3, 4, 5, 6 is there. Now 7. An applicant who is not an owner but an occupier shall, along with any one of the documents listed at 1 to 6 above, also furnish a no objection certificate from the owner. Now, very interestingly, this runs counter to the Electricity Act, which does not require any such thing, and the rules thereof. Now, in the meantime, a second development happens, that is at page 54. At page 54, the Joint Electricity Regulatory Commission's regulations for a consumer grievances redressal forum comes out. And this sets up a forum wherein a consumer, an existing consumer, can come and raise any sort of grievances with regard to his supply. Now, in this background, what happens is an order is issued by the administration, where the administration claims to say that, well, you need to demonstrate by way of a document of no objection that you are in a settled position which must be verified from the Revenue Department. This notification has never seen the light of day. We have only the references to it from orders passed in different proceedings. Now, in the meantime, in pursuance of that grievance redressal regulation, the grievance redressal authority is set up. You also will get that at page 92.
Yes.
Page 92, your Lordship will see the fourth paragraph. The Lieutenant Governor is pleased to constitute a forum consisting of the following: R. Ravichandar, Narayan Chandra Baroi, BG Thomas. Now, the extract of that circular, that notification, is at page 94. Page 94, the second paragraph.
Yes.
Andaman and Nicobar Administration circulated a circular number 4/so-and-so dated 9/10/2023 stating A. Must be residing in encroached revenue land only and shall not be applicable for encroached forest area. This is accepted. B. Must not be a government servant. C. Only domestic. D. Procedure. Now, under the procedure, subclause 1 deals with the application. Subclause 2 says the application shall be provisionally accepted and the application shall be forwarded to the concerned revenue authority for confirmation whether the applicant is in settled possession or not. So this was a new thing that came. So every time you make an application, that application is now being sent to the revenue authorities and it's sitting there for months on end because the revenue authorities have to give this no objection certificate. Now, in this background, two cases come up before the court, before the forum. The first of these cases is a peculiar situation where my lords will find this particular circular is quashed. It is set aside altogether, and thereafter, on the basis of setting aside of that order, the Consumer Grievance Redressal Forum says you cannot ask for these documents. Now, surprisingly, the quashing of that order is completely suppressed. And thereafter, your lordships will find from page 114 onwards, the situation before this honorable court now becomes complicated. Page 114, first of all, this is a writ petition heard by the single bench of this honorable court. Now here, my Lord Justice Madhuresh Prasad, as his lordship then was, comes and takes up the matter WPA 194 Santosh.
Yes.
21st March 2024, this order is passed. His lordship says three things. Number one, Abhimanyu Mazumdar in the constitution bench is not good law. Because that explanation was not there, the judge. Therefore, they considered the argumented law. Therefore, it is incorrect law. We will not consider Abhimanyu Mazumdar going forward. Number two, that because the new JERC regulations have come, where 530 requires that document, so you will have to provide a no objection document. And on that basis, it is said that Abhimanyu Mazumdar is no longer good law, and this will not be followed. Now, this particular order that is passed is not challenged in any form. However, the difficulty arises because another circuit bench comes here, that is at page 139. Here, their lordships, while hearing a series of applications together, the first one, the title is Sushil Latta, WPA 215 of 24. So we have a three-judge bench which has been followed for a decade. Now a single bench says that's not good law, but does not refer it upwards. Now at page 139, another single bench comes, which is hearing the matter. The relevant portion starts from page 143. Now this is an order passed by Madam Justice Shobhashachi Bhattacharya, who considers the old law, the new law, Abhimanyu Mazumdar, and says, sorry, Abhimanyu Mazumdar is correct. You will follow. Now things get worse. At page 148, the third bench comes in September. Now this is my Lord Justice Arina Mukherjee, who looks at Justice Prasad's order, looks at Justice Bhattacharya's order, frames whole new questions, and says not only is Abhimanyu Mazumdar correct, but more importantly, as of now, this is a right under Article 21. What Abhimanyu Mazumdar did not answer, I am answering. It's part of the right to life. You go and give everyone electricity connections. The question of right title interest over the property will remain open. That is to be seen. Now, unfortunately, what is happening is when people are applying for electricity, in the meantime, I must show one more thing. The fact that that particular order had been quashed, which I had submitted at page 152. In October 2024, that same grievance redressal forum takes up the matter, considers the applicability of that circular in light of the JERC regulations and in light of the Electricity Act, and says that this circular is completely illegal and we are setting it aside.
This page 158.
Yes, that is the regulatory commission's order. Now, in this background, what is the actual legal position as on date? 9th October 2023 circular notification is gone because the Consumer Grievance Redressal Forum says it's illegal in terms of the JERC regulation, in terms of the Electricity Act. Abhimanyu Mazumdar was on, switched off, switched back on. Now a single bench has confirmed Abhimanyu and confirmed the circular has no application. Now, when we apply for electricity, kindly see what is being said. They are now relying on documents. Kindly take up the writ petition. Kindly see page 26.
This is your declaration.
This is my declaration, which I am required to do. Now, after this declaration is given, page 30 is the online application status. No order is issued, nothing is done. The status says at the bottom left,
Rejected.
And now kindly see the remarks. As your application was forwarded to Tehsildar Sri Vijayapuram, it's continued on the next page.
Yes.
For settled position, we did letter number so and so. After getting the reply from the Tehsildar, we did letter number so and so, it states to strongly condemn any encroachment on government land and granting of electricity connection to individuals who claim ownership of such land. You are following a circular which doesn't exist. More importantly, the difficulty that arises now is, with the greatest of respect and humility, I'm saying this, there are all sorts of extraneous considerations entering the picture. Because they say we have our circular, we say the circular squash. They say no, we've sent it, you take it up with the Tehsildar. Now run on to the Tehsildar for 1 year. Now the Tehsildar gives a report saying you're not the owner. Well, I don't need to be the owner because Abhimanyu Majumdar says so. Now they say no, Santosh says Abhimanyu Majumdar is wrong. Now I'm saying Lakra has said Santosh is wrong. And this game is being played. And what is happening is every circuit your lordship would have seen on the first day, there are 30 electricity matters being filed. Where 30 people come, in the usual cases, a mandamus is issued and they get their connection. Now, this petition has been deprived of electricity since the last, I think this has been pending since 2025 July probably. The difficulty is that now these points, till one bench comes and clarifies this once and for all, is something which leaves it hanging over applicants, litigants.
No, but clarification has come from Mr. Mukherjee.
They are
Justice
following.
Mukherjee has already
They are not
clarified.
following it.
They are not seeking.
If your lordship sees their affidavit in opposition, if your
Sorry?
lordship sees the
We are not
opposition,
seeking right now, we are not seeking any permission from the Tehsildar.
If you're not, then
Then
you consider a case.
Lordship, I am challenging the maintainability of this writ petition. Lordship.
On
So
what
let it-
ground?
Let it
No,
come.
maintainability. On what ground are you challenging the maintainability?
First of all, Lordship, there is a forum called CGRF. He has to approach before the CGRF.
That is all right. What
And
else?
moreover, he is saying that we have taken, we have sent the letter to Tehsildar for getting the settled possession report.
That is not
And
done.
Tehsildar is not a party to this case.
That is not required. You are yourself making a statement that the no objection from the Tehsildar is no longer a condition.
Yes.
So forget about that. That goes
I know just see page
in
8.
view of your
In
own.
regard to survey number, we have.
Mr. Mishra.
Number is correct or not?
Mr. Mishra, no need for that. In view of the judgment passed by Justice Mukherjee, any person who is in possession has to be given. As far as the circular is concerned, that is already gone. You are at you.
CGRF doesn't have power to pass the circular.
We are not getting into CGRF at all. You yourself are making a statement that you are no longer.
Because he has
Wait a
told the
minute.
lordship that-
Let's not get into. You are making this statement, Mr. Mishra, that you are no longer asking for any kind of
No objection.
no objection,
Lordship.
right? So let us forget what CGRF has done. You want to challenge that order, you challenge that order. You are entitled to challenge that order.
Which order, Lordship?
CGRF order, if you want to.
Lordship, that CGRF doesn't.
I'm not
have-
getting into it. Whether they have power, they don't have power is also you will challenge it. I'm not getting, why should I get into CGRF order? I'm not even relying. I'm not relying on it, sir. I'm relying on your statement.
Let it come on Tuesday, Lordship, I will make appropriate.
If today your statement is that you still require NOC, then I will look into whatever I have to. If not, then we are going ahead, we are passing an
Take
order.
instruction and come.
Take instruction, give it to her.
And moreover,
Kindly see the affidavit in opposition page 8. With the greatest of respect, this statement is confirmations. Page 8, paragraph 10.
Yes.
This is their actual stand today. Santosh is correct. Sushil Lakra and Justice Mukherjee's judgments are wrong. This is their stand. This is the problem.
let me come back on Tuesday.
You come back on Tuesday. Let him come back on Tuesday. Not today. No. Though Mr. Kabir, What kind of clarification you want from this then?
Another may I say this in all respect. The initial propriety demanded certain. It's never happened. And I'll tell you Lordship why. Because electricity writ petitions, with respect to the bar as well, is something where you're just filing one simple thing, saying I made an application, this is the date, they haven't considered, this is the date, this is the date, and a usual order has been passed. No one has brought the provisions of law to the attention of the court in a very coherent manner. Now, if a single bench had to differ, this matter had to be placed before the Honorable the Chief Justice for either referring it to a larger bench or for questions of law to be framed. Now, that would require a 5-judge bench to come and sit here and analyze, which is something which perhaps practically may not be a very easy thing. Now, the next single bench, with all respect again, once a coordinate bench had passed an order, to what extent now, I mean, the way things have happened, one order is required because now they are continually adopting the stand that we have 3 orders, we can choose which one of them we want to follow. The idea is that it is necessary for the 3 orders and Abhimanyu Mazumdar to be harmonized.
Even if I pass an order, that will be the 4th order.
No, the 4th order will take into consideration all the law, all the previous 3 orders, and Abhimanyu.
Still, it will be a single judge bench.
My lord, even if it is a single judge bench, I am well aware that old is gold and latest is not best, and all those judgments of the Supreme Court I am aware of. But I'm equally aware that one authoritative pronouncement which we can wave in the air instead of having 3 is something which will benefit A, litigants, B, lawyers. When we take up these matters, we should be in a position to say that this is what the law is.
And you get your written argument on this.
Yes.
Give me a written argument.
Tuesday.
Mr. Mishra, if you are granting, then don't get me anything. If you are not, then come up with your written arguments. I think the good sense will prevail and you'll grant them an reconnection. So that you'll leave it,
Without further
so-
implicating.
so you'll leave it for other benches to decide other issues.
Deeply well.
One thing can be done also, that the order which has been passed by the status report which has been given in by the assistant engineer.
No, I-
Set aside and
Yes,
necessary
that's
direction.
what, that's what,
Let it be on Tuesday. or
that's what I'll do. I'll set aside the directions, I'll set aside the rejection and in view of the statement made by you that it is no longer incumbent on the administration to seek for a NOC. You will decide the case in terms of whatever the direction that.
In fact, my lord, with the greatest of respect, don't take me otherwise, but these other 20 matters in the list, you have to follow the same law.
Let all the matters be picked on Tuesday or Wednesday.
No, I'm not standing in the way of my learned friends who are moving their matters. I'm just saying that.
You were supposed to take instruction. Have you taken instruction or you want it on Tuesday for the other? We'll see. Let the other matters be.
That's it.
Yes, madam. Now, tell me.
Petition.
Yes, Tuesday. Not today. Hey,
For 192, my lords.
yes,
Let him make his submission, you know, should deny.
yes. Who's for the
I am
petitioner?
appearing on behalf of the petitioner, Lord.
Ms. Nag, you're for the petitioner.
Lordship.
I am for the private.
Kindly come to page number 41, Lord. I want the demolition order which has been passed by the Secretary Portfolio Municipal Council should be
Oh, this is that many rounds of litigation.
Lordship.
Yes.
They should comply their order. That is my prayer.
Where is?
Page number 41, Lordship. This is the order passed on 19 December 2020. And the Deputy Commissioner, the Appellate Authority passed
43.
43. It is the Appellate Authority who has affirmed the order passed
This is what you want? You want compliance of this order?
I want compliance of order dated 19 December 2020.
Yes, the earlier,
It was affirmed by the appellate authority.
yes. Where is the order of the appellate authority?
Page number 43, Lord.
43. Appellate authority is page 44.
44:11.
This is the 11th of September order, right? Appellate authority.
Lord,
Ms. Nag,
Yes,
who are you appearing for?
Your Lordship. The order dated 11th September 2024. I challenged the order, Your Lordship, before the appellate court. This particular order was never communicated. I am unaware of this order. However,
Yeah.
soon after coming to know about this order, because once the writ application was supplied to my client, I preferred the appeal before the Lieutenant Governor. This is the copy of the appeal. And this is a judgment. I will give a copy. And this is a judgment of the coordinate bench, Your Lordship, where similar situation arose. When appeal is pending, the court has said that the appeal will be disposed of first. No, one jump.
it was filed today.
Because I was not aware. Let them show the order of the deputy commissioner has been communicated to my client.
Lord,
Let
that
them
is
show.
the counsel for the the record may kindly be called forward.
Yes, I am agreeable to that.
The record may kindly be called.
Because we have filed the adjournment application before the deputy commissioner assigning certain reasons. And thereafter, when the order was passed, we were not aware of that at all. And that ground also I have taken in the appeal.
Yeah, you're saying you're not been informed of the order.
Yes, Your Lordship, we were not informed. Let them show that it was informed to us.
What do you want?
Lordship,
I can give a direction to the appellate authority to decide it.
Lordship, it was filed yesterday only, today only,
What was
after
that?
filing of the writ petition.
She has filed it today.
But after, there is a
If
delay
the-
of 366 days, Lordship.
That is for
And there is
the,
timeline.
that is
And
for
we have
the,
not obtained any stay from the appellate authority.
that is
If
for,
the stay is there, I could have withdrawn my writ petition right now.
no stay, it's all right, but still, she has challenged the order.
Let me get a copy, Lordship, so that.
Give
I
a
can-
copy, we'll have it next week. Give a copy.
I'll give.
We'll have it next week then.
Wednesday.
Wednesday. Wednesday. Not today.
I have appeared on last occasion and I got instructions.
Yes.
The petitioner is an wife of a deceased. It was an employee of the council. But in the, after his, he being a wife, she is entitled, but not in his record, and other the declaration of the nominee or the declaration which should be next, and nothing has been, he has enclosed the names.
The legal aid certificate needs to.
That has been submitted.
It can be communicated by the authorities, either you produce success, legal certificate or success certificate.
Page number,
Based on that, you will get the
page number 22, my lord.
23.
22 annexure P3.
This is.
This is the legal certificate of the deceased person that this many persons are the legal heirs of the
This
certificate.
is not legal aid certificate. This is a family
Family legal
certificate.
certificate, that to be an
This is,
affidavit.
this will not suffice for legal aid certificates. There's a judgment of Madras High Court,
My,
which very clearly
Page number
states
23, the authorities are specifically mentioned. Page number 23, you kindly be seen.
you have to give that certificate, sir. If you're challenging this, I'll dismiss it. Take down. The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondents in not deciding her application for release of the pensionary benefits of her late husband, Shri U. Balakrishnan, who was serving as a sanitary Mazdoor under Shri Vijaypura Council. Full stop. The husband of the petitioner expired on 20th March 2024, leaving behind the petitioner bracket my wife and 3 children and his mother as surviving dependents. Full stop. The petitioner obtained a family member certificate dated 15th April 2025 from the Tehsildar, Shri Vijayapuram Tehsil, South Andaman. Full stop. On the basis of the said certificate, she applied for release of her pensionary benefits. Full stop. The respondent number 3, however, via communication dated 30th April 2025, directed the petitioner to produce a legal heir certificate. Full stop. The petitioner contends that since she had already submitted a family membership certificate, there was no requirement for producing a separate legal heir certificate, and accordingly she submitted a representation dated 8/5/2025 requesting the respondents to release the pensionary benefits. Full stop. This court has heard the arguments advanced by the counsel for the petitioner and has perused the materials on record. Full stop. It is evident that the respondents have insisted upon submission of a legal heir certificate in terms of the governing rules / procedure for settlement of pensionary benefits. Full stop. It is well settled that a family membership certificate and a legal heir certificate are 2 distinct documents serving different purposes. Full stop. The family member certificate is generally issued by the revenue / Tehsil authority to certify the names of persons ordinarily constituting family for general and administrative purposes. Full stop. In contrast, the legal heir certificate is issued specifically to establish the lawful heirs of a deceased person and is a mandatory requirement for the settlement of pensionary and other service benefits, in order to safeguard against rival claims and disputes regarding succession. Full stop. In the present case, the petitioner has admittedly not produced the legal heir certificate as required by the respondents. Full stop. Without such certificate, the respondents cannot be compelled to process the claim, since release of pensionary benefits in the absence of legal heir certificate would not only be contrary to the established rules, but may also expose the authorities to multiplicity of claims or potential disputes in future. Full stop. This court, therefore finds no infirmity in the action of the respondent in keeping the petitioner's application in abeyance till the legal heir certificate is furnished. Full stop. The petitioner is at liberty to obtain and produce the legal heir certificate before the competent authority, upon which the respondent shall process and disburse the pensionary benefits as expeditiously as possible in accordance with law. Full stop. In view of the same, there is no merit in the present petition and the same is dismissed.
For the petitioner, you should be a very small prayer.
And for the respondent, my lord, read by Mr. Vedi Shogan.
The petitioner's husband, he has purchased a plot of land by way of a registered sale
Yes.
deed. And what has happened, your lordship, that was purchased way back in the year 1963. After his demise, when the wife went for mutation of the property, someone raised objection stating that he has a right over the property. So civil litigation was going on, civil suit was filed and he lost it before the appellate forum as well as before the trial court. And thereafter, the wife has made an application for mutation of the property, which is pending. So they have to adjudicate.
Let a direction may be given, my lordship, we will
Within a time frame, they have to dispose of.
In accordance with the-
law.
we will dispose it.
Your representation is there.
Yes, my representation appears at page 35.
Let them decide your representation.
That's it.
In accordance with law.
Maya Rani Badya, right?
That's my.
The petitioner has preferred the present writ petition challenging the inaction of the respondent in not deciding her representation dated 3/4/2025, whereby the petitioner has sought mutation of landed properties being survey numbers 320, 321, 328, 323, 324, and 332. Measuring areas 1.12 hectares, 0.6 hectares and 0.52 hectares, 0.01 hectares and 0.30 hectares, 0.07 hectares, all situated at Choldari village. Choldari village under Feraganj, Ferarganj, Tehsil, South Andaman district. Full stop. It is the case of the petitioner that her deceased husband had purchased the aforesaid landed properties from Sri Subodh Chandra Gain by the registered sale deed dated 13/6/1963. Full stop. Since then, the petitioner and her family have been in continuous possession of the aforesaid properties. Full stop. The petitioner's husband expired on
1967.
26/11, right? 26/11.
Yes.
The petitioner's husband expired. No, when did your husband expire?
My husband expired.
Later. That is the 95, right?
95.
95. The petitioner's husband
7/5/1995.
expired on 7/5/1995, leaving behind the petitioner and their 6 children as his legal heirs. After the demise of her husband, the petitioner approached the Tehsildar, Ferarganj, for mutation of the said property in her name and her children's name. Full stop. In furtherance of the mutation proceedings, she had issued a paper publication to full stop. Pursuant thereto, Shri Paresh Chandra Gain, brother of late Shri Subodh Kumar Gain, filed objections.
Alleged brother.
Alleged brother filed objections leading to initiation of revenue case number 141 of 2007 before the Tehsildar Ferrarganj. Full stop. While order dated 26/2/2007, the said case was disposed of, directing the parties to approach the competent civil court for appropriate release. Full stop. Consequently, Shri Paresh Chandra Gain instituted titled suit number 107 of 2010, which, after due adjudication, came to be dismissed by judgment and decree dated 31/12/2018. Full stop. The appeal preferred against the said judgment and decree, being appeal number 05 of 2018, was also dismissed while order dated 26/2/2025. Full stop. Subsequently thereto, the petitioner submitted a representation dated 3/4/2025 for the respondent authority seeking mutation of the aforesaid property in her name and that of her children. Full stop. However, till date, no final decision has been taken by the respondent authorities. Full stop. Being agreed by such inaction and failure on part of the respondent to decide representation, the petitioner has preferred, the petitioner is constrained to file the present writ petition. Learned counsel for the respondent authority submits that respondent authority, you appear for all, right?
Only one
Sole respondent, my
The
lord.
respondent, learned counsel for the respondent submits that they are ready and willing to decide petitioner's representation dated 3rd April 2025 within a time bound manner. Full stop. To decide the representation. Full stop. Learned counsel for the petitioner states that she shall be satisfied if the same is decided within a time bound manner. Full stop. In view of the same, the present petition is disposed of in a direction to the respondent to consider petitioner's representation dated 3/4/2025 within a period of
8 weeks, my lord.
8 weeks from today, after affording an opportunity of personal hearing to the petitioner as well as the other stakeholders. Full stop. The final decision shall be
If
published.
any, your lordship.
Other stakeholders, if any. If any. Full stop. By way of speaking. Full stop. In the above direction, the present petition is disposed of.
My lordship, since we have not used the above, my lordship, all the allegation made in the writ petition that deemed to be denied and dismissed.
After affording an opportunity of hearing to the petitioner or any other stakeholder, in accordance with law, by way of speaking.
Obligors.
Lordship, item number
For the petition.
6/13, Mr. Karmakar is appearing for the state lordship. Can it be taken up in the next circuit bench?
What are these?
For private respondent, senior counsel Mrs. Nagi is appearing, your lordship.
At the request of the parties, let this matter be listed before. At
Let
the
it be.
learned counsel for the respondent state submits that the main arguing counsel is in some personal difficulty and prays for this matter to be listed before the next available circuit bench. Let this matter be at his prayer, let this matter be listed before the next available circuit bench. Who's appearing? Who's the main counsel here? Mister? Where is he?
The state.
Private respondent.
Where is he, Mr. Karmakar?
Yes, only flex before the other.
We'll keep it for the next circuit then. We could have finished it. We could have finished it. Why do you want next circuit?
Let it be on Wednesday or Thursday then, lordship.
Huh?
Let it be on Wednesday or
You
Thursday.
can finish it off. Not today. Let's finish it. Wednesday.
Lordship,
Wednesday. Why keep these matters pending?
lordship.
The same next on Monday, your lordship.
Wednesday.
Wednesday, you tell Ms. Nag to be here.
Wednesday.
Your lordship.
What do Wednesday? Here also Lordship, Mr. Karmakar is appearing for the state.
Where did the caller, madam,
Madam,
caller?
madam. तो विनीता गई लगता है, विनीता.
All right. Item those connected matters. I kept it on Wednesday 9 to 14.
Your lordship, we'll do it. Your lordship, item number 14.
Yes, 14.
Here, your lordship, I am just seeking that the conditional order which has been passed by the subdivisional magistrate, it is on the basis of initiation of a case. That has to be concluded. I'm seeking only that.
Let it just not today, Lordship.
Seek instruction.
Let's,
Because he's not concluding the case.
Let
Mr.
time
Karmakar.
ask Mr. Karmakar to seek instruction.
Yes,
We can pass such direction and finish it off.
to finish it off, that's it. Obliged.
Not today. When do you want, Ms. Nag? Wednesday?
Monday,
Let
you can
it,
take instructions.
Let's not have, Wednesday would be better.
Your lordship,
You know how department functions.
your lordship.
Wednesday,
public.
14 Wednesday.
आराम से निकाल.
Yes.
I see it ended before 4 number 1.
Or not today. Not. Ms. Das, did you,
No, it is that matter.
that matter?
Yes, ma'am.
You have got instruction?
Yes, ma'am. On the basis of a preliminary decree, he has got before the festival, because the decree which he has attached, it is not a final decree, you know. It is a preliminary decree. Thereafter, he has to file for partition company, because straight away he has, because mutation.
He has to go for the execution of the decree then.
Yes, after final decree. That is.
We'll have it,
They.
Monday.
For the festival and for mutation of the land.
Monday we'll have it.
Monday.
Monday.
This matter also, my lord, affidavit in opposition has to be filed by the other side. The self same matter, my lord, in court number 1 has passed the order, not it uploaded by the.
Give Monday, not today, Monday.
My lord, in this matter, Mr. Rakesh Kumar actually is appearing. My name is wrongly appearing, Lord. I'm not there. Item number 16.
Item 16.
Mr. Rakesh Kumar is appearing. Rakesh Kumar.
In the list, I don't know why it is there.
Mine.
Make a correction in the list. Item 16.
Monday.
Monday we'll have it. Ms. Bhavita, we'll have it on Monday.
Fine,
You're not
fine.
there. Electricity matters,
Lordship 17 to,
all on Tuesday.
Lordship 17 to 32.
Tuesday.
Lordship. Instead of Tuesday, let it come on Wednesday.
You lordship.
Yes, I know.
Your lordship, so it, the order may be done, your.
That's why I'm keeping it on Wednesday. All right. All these matters on Wednesday.
Public.
Rest tomorrow. Huh? All HCD matters on this one. Not crops. Item Madam. 7. Just explain it. 17. Here there is some other regulation. Mr. Kabir was showing me some regulation where there's some exemption for the circuit bench.
It is normal practice.
Normal?
The practice of this.
Calcutta High Court, I know the normal practice, it goes before the regular bench.
Same thing.
No, here there is some, please check the rules on the other side.
I have to check.
Just have a look.
I will check.
Have a look.
I'll check it now.
Not today. Just have a look at that.